Lordship, with your apology, I have to seek the adjournment again. Item number 25. Your Lordship, here, just now I received a call from my son that my immediate neighbor expired this morning.
Okay,
So I have to leave for Timapo.
okay.
So this matter will be listed on 14th of this month.
Other side, okay. Sri so Leonard State Council has submitted that due to some personal problems, the matter is required to be adjourned. Full stop. On request, list on 14/11.
14/11.
Yes.
Interim continued.
Interim order passed earlier to continue till the next date of listing.
May I please, Your Lordship, may I be pleased to mention hearing item number 19, 20, and 21. Your Lordship, let it come after winter vacation because Your Lordship,
These are old matters.
similar matter has been is pending before the Apex Court, Your Lordship.
But
There's a challenge to the policy.
these are old matters, madam, 20 matters.
That's why, Your Lordship, the matter is being prolonging because, Your Lordship, similar matter is under challenge, Your Lordship.
Now, what is the status in the Honorable Supreme Court?
Lordship is still pending, Your Lordship.
Now, what is the status? Is there any stay order? This are to be disposed of in terms of the earlier orders.
Then, Your Lordship, if the matter can come up after a week, then we can take it up.
Not after the vacation. 20 matters doesn't look good. We are on almost end of 2025. Writ petitions pending since 5
Yes.
years.
Lordship, then after a week, we can take it up.
Okay,
Lordship.
next week.
Yes, Your Lord. Petition is absent.
London State Council has submitted that similar issue is pending adjudication before the Honorable Supreme Court. Para. Para, and accordingly praised for an adjournment. Para. However, considering that these matters are pending since the year 2020, while adjournment is granted, the same are directed to be listed after a week. Yes,
Much obliged, Lordship.
19, 20, 21.
May I please, Your Lordship, I'd like to mention item 22. Your Lordship, my senior is out of station, so if the matter may be fixed for 18th of November.
Yeah, for the petitioner.
Yes, Your Lordship.
A request for adjournment has been made on behalf of Sri A. Jimomi, Learned Counsel for the petitioner. Sarah, on request, list on
18th November.
18/11.
My Lord,
Lordship, this-
I'm for respondent number 4.
Sri so-and-so, the Learned State Council as well as Sri so-and-so. You are Soto.
Yes,
Sri
B.
Soto, Learned Council for respondent number 4 are present.
My Lord.
Give the names of the State Council also.
Your Lordship, this is an interim, if it may be continued.
Sarah, interim order passed earlier to continue till the next date of listing.
Much obliged.
May I please, Your Lordship. Lordship, kindly allow me to mention item number 14, Lordship.
1/4.
Lordship, on behalf of the Blue Arm only, Lordship. Lordship, here I'm yet to file my reply today, additional affidavit filed by the petitioner. Kindly allow me 3 weeks time, Lordship.
14 will have to check the records. Why is it come for orders? It may be for steps or something. Wait for your turn. We'll see, check the records. We'll grant you time. No problem.
Lordship.
There may be some other issues also.
Lordship.
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 Lordship, I'd like to mention item number 26.
Hmm.
Lordship, here we want to file an additional affidavit to bring in new developments.
Yeah, for the petitioner.
Yes, Lordship. Pending grant us 3 weeks.
Ms. So-and-so Learned Counsel for the petitioner submits that there are certain developments in this case which she would like to bring on record by filing an affidavit. Full stop. Para. Accordingly, matter is adjourned by 3 weeks to enable filing of such affidavit.
Obliged, Lordship.
Yes, Lordship.
Yes.
Lordship, I beg to mention item number 2, Lordship.
Yes.
With 3 weeks time, I'm granted to me and I've given opposition, Lordship.
You've got the instructions.
Lordship.
Have you received the instructions? 24 matter, why have you not received the instructions? You should get the instructions. Ms. So-and-so Learned State Council prays for and is granted further 4 weeks time to obtain instructions / file affidavit in opposition. Yes.
Lordship, I have similar prayer for item 5 as well, Lordship.
Instructions received.
Not yet, Lordship.
This is also 24, same matter, same order, 4 weeks for instructions, less filing affidavit of petition.
Lordship, I have similar query for item 7 on behalf of my colleague.
Instructions received.
Not yet, Lordship.
Okay, same order, 4 weeks.
Lordship, item number 8 to 11, 8, 9, 10, and 11, Lordship.
Hmm. Yes.
So, yes, I'm yet to receive instructions, Lordship.
Oh. 8, 9, 10, 11, same, one order, common order, same order, wait, filed, 4 weeks. Is there an interim order here? No. Okay.
Lordship,
Yeah, it seems you have some objection.
No, Lordship.
You should have objection.
Of course, Lordship, it has been pending for quite some time, but
Yes. See, there were objections. Okay. Next time you be serious on your objections. Okay, next.
Lordship, item number 13 as well, Lordship.
13, yes, madam,
No objection, Lordship.
13, same order, huh? 4 weeks.
Lordship. Lordship, Lordship.
Next, my lord. My lord, I beg mention item number 5,
Hmm.
4. 3 and 4. 3 and 4 connected.
Yes.
I am the petitioner in item number 4.
Hmm.
My lord, the respondents have filed an affidavit, petition affidavit, and I'm yet to file and reply to that. So I've given at least 2 to 3 weeks times to file reply.
Okay, you want to file your rejoinder affidavit? Yes, Sri so-and-so learned counsel appearing in WPC 1/8/2024 prays for and is granted 3 weeks time to file rejoinder affidavit.
Lord,
List after 3 weeks.
I reply.
This will be a common order in 3 and 4, huh?
I reply.
And so far as 3 is concerned, what about the pleadings in 3?
I'm the petitioner and I think
What about the pleadings?
he has completed.
Complete, okay.
My pleasure, Rashid. Rashid, if I may be allowed to make a mention item number 2
Hmm.
on behalf of Mr. Pakin Richabo.
2 has been mentioned already. We cannot adjourn for two occasions. It will be double adjournment.
For motion, item number 1.
Yes.
I was terminated from service, Lordship, without any show.
Were you in a hurry in filing the petition?
Lordship.
It seems you were in a hurry in filing the petition. Just have a look at the petition.
Lordship.
What is the page number of the affidavit?
14, Lordship.
Thereafter,
Yes, Lordship.
no page.
My apologies, Lordship.
You have given the index. Pages are there, but the body does not contain the page numbers.
My apologies, Lordship.
You should take care. Okay. You fill up the pages. Oh, pages, okay.
If this matter may be called.
No, we'll do it now, but be careful in filing, presenting a petition.
Lordship, my apologies.
If the index was also vacant, blank matter would have been different, but you know that there are pages. Third, Sri so-and-so learned counsel for the petitioner who is aggrieved by an order of termination of service dated 11/9/2025, followed by an appointment order of the respondent number 5, wide order dated 30/9/2025, full stop. It is the case of the petitioner that he was initially appointed in the year 2013 as an area coordinator and was subsequently appointed as block program manager within bracket BPM in the year 2017. Let notice be issued, returnable by 6 weeks. Yes, who's taking notice?
1, 3, and 4.
Ms. So-and-so learned state council for 1, 3, and 4. What about 2? CGC, any central government council? Sri so-and-so CGC for respondent number 2. Let extra copies be served upon them within 2 days. Steps for service of notice upon the respondent number 5 be taken by registered post with AD. Steps within 2 working days. Okay. Given the page numbers.
For admission, item number 6.
Yes.
And please, Your Lordship.
Hmm.
Your Lordship, in this case, the petitioner is aggrieved by the deduction of 16 months' salary amounting to rupees 9,74,310 from his pensionary benefits on account of overstay in service.
Okay, overstay.
Yes, Your Lordship. Your Lordship, the petitioner was appointed as LDA to the office of the district sports officer in the year 1987 as a subsidy for 2 months. If Your Lordship may kindly come to Annexure 1, page 17, where his appointment order is annexed.
In the year 1987.
Yes, Your Lordship. For 2 months. Your Lordship may kindly come to page 17, Annexure 1.
Yes. Then what happened?
Then the petitioner was allowed to continue in service until his regularization in the year 1989 by order dated 29 March 1989 with effect from 1st April 1989.
Yes.
Your Lordship, in the service book of the petitioner as well, his date of appointment is mentioned as appointed by order dated 29th March 1989, which is his date of regularization. Your Lordship may turn to page number 21 to have a look at his service book.
2-1.
Relevant page is at page number 21, 22, Your Lordship. And the type copy is at page number 23.
Yes, 29-3.
Here it said, he has been appointed to temporarily act as LDA in the scale pay of such and such by order number such and such dated 29 March 1989.
Yes, yes.
This is regularization order.
Hmm.
Your Honor, the petitioner was promoted to the post of UDA in the year 2018, sorry.
Yes.
Then in the year 2019, a seniority list was circulated of all the LDAs in the department. In the seniority list, the name of the petitioner appears as serial number 24. The seniority list is at page number 28.
28.
Yes, Your Honor. Relevant page is at page number 28. The name of the petitioner appears as serial number 24. Your Honor, in column number 5, the date of joining service is reflected as 1st April 1989, and his date of retirement is reflected as 31st March 2024.
Seniority list, your serial number 24.
Yes, at serial number 24.
Let us see.
Therefore, also
24, yes.
his date of retirement as 31st March 2024.
Date of retirement. 31st
March 2024.
Yes.
Your Lordship, all along the department has taken my date of regularization as my date of entry into the service and my date of retirement as 31st March 2024. Thereafter, in the year 2023, by latest dated 17 April 2023, the respondent number 3 wrote to respondent number 2 regarding the date of appointment of the petitioner for entry in PIMS. Your Lordship, by this letter, it was through this letter that for the first time, the department said that the petitioner's date of joining the service is 1st 2nd January 1987, which is his appointment as substitute LDA. And his date of regularization is 1st April 1989. Before this, the petitioner, the department has all along said that my date of appointment is my date of regularization. It was only through this letter that the department has stated that my date of entry into the service is substitute LDA is my date of entry into the service. Then the petitioner was verbally informed in the office that he ought to have retired with effect from February 2022, counting his length of service from 2nd January 1987. Therefore, the petitioner made a representation on 25th June 2023, stating that his date of retirement, according to his service book, is 2024, and requested the authority to look into the matter. However, instead of looking into the matter, the department, by order dated 30 June 2023, the respondent number 3 ordered that the pay be stopped immediately for the petitioner on account of overstay in service, and all the pension papers of the petitioner be kept in abeyance until the matter of the petitioner is resolved. Then this is at page number 32, annexure 8. Here it is written, establishment of the district sports officer Mokokchong, Shri O Mwa Insong, should be stopped immediately on account of overstay in service detected. Further, his release order, pension papers, and all other relevant matters pertaining to his service will be kept in abeyance till the case is clear.
In the meantime, were you released or were you still in service?
Your Lordship, the petitioner was attending to his services as UDA until June 2024. And when he learned that he was supposed to be, when he learned that he was to be retired with effect from February 2022, he stopped attending to his service sometime in June 2023.
No. Till when did you actually serve?
June 2023, Your Honor.
23.
Yes,
You discharged your duties.
yes, Your Honor.
And the recovery of this amount which you had indicated
Yes.
is for which period? Recovery from the pension?
Yes, recovery for 16 months overstay from February 2022 to May 2023.
16 months from
February 2022
to?
May 2023.
But from February 2022
Yes, Your
to
Honor.
May 2023, where you paid your remuneration,
Your Honor, I was being paid.
then you'll not get the pension. You cannot get the pension and remuneration for the same period. Had it been case that for overstay, a recovery is sought to be made from your pension after you had retired.
Yes, Your-
But here, for that period, you are already paid the remuneration.
Your Honor, it was paid, my salary was paid, and it was deducted from my pensionary benefits.
No. Then see, there will be either two things. Either from 2023 you will get the pension
Yes, Your Honor.
or you will get the remuneration. Now, you say you are paid the remuneration. And if the remuneration has been paid, so your pension, the practical date from where the pensionary benefits will be given to you would be after 2023.
Yes, Your Honor. However, I was made to work for 16 months.
Now, for that period will be entitled to the remuneration. We'll seek the clarification from this council. These matters are no longer res integra. It has been settled in many matters. Overstay for this kind of post, no deduction from pension. But at the same time, we have to strike a balance. State cannot pay twice. For the period you are being paid remuneration, for the period you are being paid pension, it cannot be. So we'll seek the clarification. If the remuneration is not been paid, or if this deducted amount is a part of the remuneration, it has to be given back to you. But the pension has to be counted only from the actual date of your discharge discharge from service, that is in June 2023. It cannot be from 2022. That is what it's our opinion. Yes, you for whom?
For AG, the respondent.
Okay, I think decision is by the state.
I'm from the state, we will find a detailed affidavit, so I'll be referring to 3 paragraphs.
Only clarified one issue.
Lordship.
This deduction, what is the amount, madam, deduction? 16 what? 16 lakhs?
9,74,310.
Rupees 9 lakhs,
74,000.
74,310. Okay, this is the deduction amount.
Yes.
This amount, you just need to clarify, is a part of the remuneration which you had paid for the period February 2022 to May 2023, or is it something else?
It is a renew.
If it is remuneration, then you have to pay the pension from February 2022.
Your Lordship.
See, you cannot extract the services in gratis.
That's true.
There may be a case of overstay. If we find that the incumbent did not have a overt act or role in the overstay, then normally we do not interfere. And more so when this post concerns grade 3, grade 4. Higher posts are different.
Yes, Your Lordship.
This has been explained in grade, is grade 2?
Yes. Yes, your grade 3 post.
Grade 3, I think.
He is retiring as a UDA.
UDA is grade 3.
It's a grade 3 post.
Grade 3. It's UDA, LDA are called grade 3. These are not officers' posts, these are ministerial posts.
Yes.
So, what Rafiq Masi has clarified, that if somebody has overstayed, normally you should not deduct. Okay, unless there is an overt act in the overstay. There is no overt act. We do not find that their petitioner had himself played a role in his overstay. Some mistake had happened, he continued. And now, you cannot deduct the salary, but we will give you the liberty that while computing the pension, it will not be from February 2022. You are not supposed to pay remuneration as well as pension for the same period.
Yes.
The pension would be from May 2023. That part will clarify. Okay. Yes, anything from your side? That is how we will balance.
See, Your Lordship, as far as the letter that we received from the state respondent, before we made a deduction of 9 lakh something. My lord, here, the issue is the petitioner, if we look at the prayer of the petition, the petitioner is not asking for the pensionary benefits starting from May 2023. He's only asking from the period which the state has computed, that is February.
No, that will not grant.
Yes, Your Lordship.
That will not, striking the balance, we have already said.
Yes, Your Lordship.
The pension can only from May 2023.
February 2022.
No, it cannot be from February 2022. She has already worked. If
Yes,
the
Your Lordship. So what the petition?
no,
the
her
petitioner-
prayer, we are not acceding to that prayer.
My lord, if I may, my lord.
Yes.
What the petitioner is asking is, for the services that has already been utilized and rendered by the petitioner, for that 1 year, 16-month period is already deducted in the form of pension and gratuity. So what the instruction that I have from the principal accountant office is that, since as far as the law is concerned, my lord has already reported the decision of the Honorable Apex Court. So now, as far as that deduction is concerned, AG has no role to play there.
Yes.
And for the services rendered, the deduction should not have been made. But we are part of the authorities that work.
No, we'll record your submission. Don't worry. Okay.
Lord.
Please have your seat.
Chief, it may be allowed to place some authorities.
Why? Which one? Rafiq Masi.
Rafiq Mashi and State of Bihar versus Pandey Jagdishwar Prasad.
Yes. What was Rafiq Masi doing? What was his profession?
Your Lordship, it was
Whitewasher. See the whole name, complete name.
Rafiq Mashi, whitewasher, and
Yes.
Mashi, whitewasher. and
Whitewasher.
Others.
Okay. Please give the citation.
2009-3 SCC 117.
2009-3.
SCC 117.
Okay. Please have a seat. The approach to the writ court under Article 226 of the Constitution of India has been made with the following prayer, page 14. Prayer court. As per the facts projected, the petitioner was initially appointed as an LDA as a substitute LDA on 2/1/87 for a period of 2 months in the office of the district sports officer Mokokchung. Full stop. However, the said arrangement was allowed to continue, and vide an order dated 29/3/1989, his period was regularized with effect from 1/4/1989. Full stop. It is the case of the petitioner that subsequently he was promoted to the post of UDA in the year 2018. Full stop. The petitioner has also annexed a seniority list published in the year 2019, in which he is placed against serial number 24, and in the said seniority list, his date of retirement has been shown as 31/3/2024. Full stop. However, vide a communication dated 17/4/2023 issued by the director to the department, not the director, issued by the director to the commissioner, to the department, comma, the date of entry into the service was sought for. Full stop. It appears that the date of entry into the service was considered as 2/1/1987, which is the date when the petitioner was inducted as a substitute LDA. Full stop. Thereafter, the petitioner got verbal information that he ought to have retired in February 2022, and accordingly, he had submitted a representation that such retirement should be from March 2024. Full stop. Vide the impugned order dated 36/2023, comma.
The order is 29/9.
We'll come to it. Vide an order dated 36/2023, comma. There was a direction to immediately stop the pay of the petitioner on account of overstay in service. It was further directed that the release order, pension papers, and other matters pertaining to his service should be kept in abeyance. Full stop. Which is the impugned order according to you?
Annex 10,
Okay.
page number 36.
Thereafter, vide the impugned order dated 29/9/2023. 16 months salary from February 2022 to May 2023 was directed to be refunded by the petitioner, either in lump sum or from the pension gratuity. Full stop. The petitioner was also released from service on 19/10/2023. Full stop. The petitioner had thereafter submitted a representation dated 24/11/2023 along with a non-royal certificate. Full stop. Para. Para. I have heard Ms. So-and-so learned counsel for the petitioner. I have also heard Ms. So-and-so state counsel and Sri So-and-so learned standing counsel, Accountant General, Nagaland. Para. Ms. So-and-so learned counsel for the petitioner has submitted that the initial appointment due made on 2/1/1987 was on a very temporary basis as a substitute LDA, and the substantive appointment was done only by the order dated 29/3/89 with effect from 1/4/1989. Full stop. She has submitted that for that all along her entry into the service has been regarded as 1/4/1989, and in the seniority list published in the year 2019, the date of retirement was put as 31/3/2024. Full stop. It is submitted that in the aforesaid backdrop, the impugned action of recovery is absolutely unreasonable and arbitrary. Full stop. It is also submitted that the period that it is not in dispute that for the period February 2022 to May 2023, the petitioner had rendered his service, and therefore no deduction can be made for the remuneration paid to him for the aforesaid period. Full stop. It is also submitted that pension is not a bounty, but a vested right which cannot be tinkered with in a mechanical process. Para. In support of her submission, the learned counsel has relied upon the following decisions. Para. Per contra, Ms. So-and-so learned state counsel has submitted that the order dated 29/3/1989 is only an order of regularization, and the aspect that the petitioner had entered into the service on 2/1/1987 cannot be overlooked. Full stop. It is also submitted that the period from 2/1/1987 to 1/4/1989 is a part of the service rendered by the petitioner, and therefore no fault can be attributed to the decision taken to make the recovery for the period of overstay of 16 months. Full stop. She has reiterated that the petitioner ought to have retired from service in February 2022.
30 January 2022.
30
He's supposed to retire
on
on 30th January.
30 January 2022. And it is evident that for the period February 2022 to May 2023, the petitioner was in service not through, and it cannot be regarded that the period of service rendered from February 2022 to May 2023 was in accordance with law. Full stop. Para. Sri So-and-so learned standing counsel, Accountant General Nagaland, has submitted that his client has simply followed with the orders which were conveyed by the administrative department. Full stop. He has, however, clarified that in the relief prayed for, comma, the petitioner he has however clarified that from the relief prayed for, comma, it would appear that the petitioner would make double benefit, both seeking remuneration for the period from February 2022 to May 2023, as well as seeking pension from February 2022, full stop. He has submitted that even if it is presumed that no deduction can be made on the basis that the incumbent had rendered his service, comma, the pension cannot be paid for the period for which remuneration has already been paid. Para. The rival submissions have been duly considered. Para. Here you have the 30 years of service. That is the reason. Okay. Full stop. This court has been apprised that in the state of Nagaland, comma, the date of superannuation is reckoned from the date when an incumbent reaches 60 years. 60 years of 60 of age or completes 35 years of service, whichever is earlier. Full stop. In the instant case, comma, the respondent state has taken into consideration the date of 2/1/1987 to be the date of entry into the service, and therefore has made the calculation for coming to a conclusion that on 31/1/2022, the petitioner would complete 35 years of service, and therefore any period subsequent thereto when the petitioner had rendered service would not be in accordance with law. Full stop. On the other hand, comma, the petitioner has contended that such period of 35 years has to be reckoned from 1/4/89 when the services were regularized. Full stop. The reliance is also placed on the seniority list in which the date of retirement of the petitioner has been stated to be
If I may, I'm not.
31/3/2024. Yes. What is it?
Your Lordship, I'm not contesting my date of retirement.
Yes, I
As
know.
my-
I know. 2024. Full stop. Full stop. This court is, however, of the opinion that even if the aspect of overstay is taken into consideration, comma, it does not appear from the records that the petitioner had an overt role in such action. Full stop. It is also not in dispute that from February 2022 to May 2023, the petitioner had rendered his services. Full stop. In the case of Rafiq Mashi, Supra, the Honorable Supreme Court has clearly laid down the principles governing a situation of the present kind, and the relevant observations are extracted herein below. This court also cannot be oblivious of the fact that if the period of overstay is regularized, the date from which the pensionary benefits are to be reckoned is required to be taken to be the date on which the petitioner had actually discontinued his service, that is in May 2023. Full stop. Considering the above, comma, while this court is of the opinion that the impugned action wide letter dated, what is the date? 29/9/2023, to make the deduction of 16 months of salary is unsustainable in law, comma, the pensionary benefits to the petitioner is to be reckoned only from May 2023.
Pensionary benefits has to be reckoned from the date he's actually supposed to be.
No, what?
That is from 30th of.
Then he'll get double benefit. How do you give double benefit? He'll get remuneration, he'll get pension also for the period. It's for your benefit, we are saying. Okay. The aforesaid order has been made by balancing the equities, as the state cannot be burdened for double payment. Full stop. Tara. With the aforesaid observation, comma, the writ petition stands allowed. No order is to cost. It's
For admission, item number 12.
12. Who's for the state, madam? What is the matter, Mr.?
Lordship, if 2 weeks time may be granted to me, Lordship.
What was the matter?
I was denied promotion, Lordship. In fact, while serving in the,
You are presently posted as what?
retired from service,
You
I was serving as senior divisional accountant.
file your returns. Okay. On the prayer of Ms. So-and-so, London State Council, 3 weeks' time is granted to file the affidavit in opposition.
Obliged, Lordship.
For orders, item number 14.
Yes, 14. You had made some mention. Let us see why is it come for orders. Affidavit in reply filed when a petition addition has been received. You have filed your additional affidavit, reply affidavit.
Yes, Lordship, we have filed our additional affidavit, Lordship.
What about respondent number 5? Who is appearing?
Lordship, the respondent number 5 is the village council. On the last occasion, we tried to serve the copy through Dusty. However, they refused to accept the.
You filed an affidavit, okay?
Lordship.
Was there any order for Dusty?
Yes, Lordship.
Which order, madam? Yes, there's an order. Okay, yes, there's an order. Miss so-and-so learned counsel for the petitioner has submitted that by an order dated 19/8/2025, the petitioner was allowed to serve the respondent number 5 by Dusty. Full stop. She submits that though an attempt was made, the service was refused. Full stop. Let an affidavit be filed in this regard. Yeah, what about the affidavit? You have filed already. Okay. Ms. So-and-so London State Council, and 3, you are for?
James on behalf of the Blue Arm Only.
No, respond number? You have filed affidavit. Have appeared.
I filed my affidavit in opposition. However, I have not replied to her additional affidavit. If I may be allowed.
I have submitted that affidavit in opposition have been filed. Para. List after 3 weeks. By which time additional pleadings may also be filed. But you file your affidavit, okay?
Much obliged, Lordship.
Much better.
For orders, item number 15.
May it please, my lordship. Lordship, in the previous order, the
5.
respondent number 5, private respondent number 5, we have filed Talabana and it is already delivered, but respondent number 5 is not before.
Who is 5? You're five for five.
No, Lordship, I'm for the one for the state.
State, five, who's five, madam?
5 is a private respondent
Okay.
who was appointed in land owner post, grade 4 post. I'm challenging that. It is already delivered as per the Department of Post Government of India Ministry.
Okay. Since the office note dated 29/10/2025, as per which the respondent number 5 appears to have been served, full stop para. In view of the above, service is deemed to be complete. Para, list after 2 weeks for admission. Have you filed your pleadings?
No, Lordship, I'm here to file.
You, no, then you have to, para, Ms. So-and-so Leonard State Council, prays for, and is granted 3 weeks' time to file the affidavit in opposition.
Obliged, Lordship.
For orders, item number 16.
My bless your lordship. Lordship, I'm for a respondent number 1, and I'm yet to file my affidavit, your lordship. So,
Item number?
16, your lordship.
Okay, who's respondent number 1?
Your lordship, I'm for a respondent number 1.
Who's
Union.
Union? Okay. Let them file the affidavit.
No, Your Lordship.
Let them file the
Lordship,
affidavit.
Lordship.
Okay. Sri So-and-so Leonard CGC prays for and is granted 4 weeks' time to file the affidavit in opposition.
Lordship.
Is there any interim order?
Yes, Lordship, there's an interim, Lordship.
Interim order passed earlier to continue till the next date of listing.
Last one.
For orders, item number 17.
Your lordship, same prayer here.
Same.
Yes, Lordship.
Interim order is also there.
Yes, Lordship.
Okay, same order.
Obliged one.
For orders, item number 18.
Your lordship, same prayer for the respondent number 1.
Lordship, this is the first returnable debt. The service of notice upon the respondent 6, 7, and 8 has returned unserved. So it can be listed after 3 weeks, my lord.
Let us see if it's returned answer. We have to take fresh steps. Let us see the
My
file.
lord. This is only the first returnable debt.
Service reports are awaited. Oh, it's not unserved. It's awaited.
My lord.
Okay. See in the office note dated 30/10/2025, as per which notice by registered post with AD were issued to the respondent number 6 TO28 on 6/9/2025. Full stop. Considering the same as per which service report is awaited, comma, list after 3 weeks along with fresh service report.
My lord.
In the meantime, the Leonard CGC, you'll also file affidavit. Leonard CGC may file the affidavit.
Lord, there's an interim.
Interim order passed earlier to continue the next date of listing. Yes.
Obliged.
For hearing, item numbers 23 and 24.
Yes.
May I please, my lord? Your lordship here, WBC 220 of 2022, your lordship. Here the petitioners, that is the.
We'll take 221st.
Lordship,
Both are connected.
lordship. Lordship, here the petitioners, they are the all Nagaland Directorate and District Government Drivers Union, your lordship. And then they are represented by the President and General Secretary of the Union.
Yes.
And then here, the case is about where the state respondents is agreed that they will provide one post of head driver to all the directorates and DC offices in the state. This is the case where the petitioner has before this honorable court, lordship.
They agreed that they will provide one post of head driver
Yes,
in each directorate.
directorate and district of DC offices.
Then that has not been done.
Lordships have some of departments, 39 departments have been granted. And then 12 departments have not been granted till date.
12 yet to be done.
Yes, lordship.
You are on the aspect that why this 12 has not been
Lordship.
done. Yes, who's there? These are not very serious disputed issues.
Shipsy, if you turn to page 18 of the 18 of the writ petition.
18.
Yes, this is the meeting minutes only.
Hmm.
18. 17 is the original one and 18 is the type copy.
Okay.
And the petitioner is relying on this meeting minutes.
Yes.
Whereas this meeting minutes has not been culminated into any order, Lordship. And as per the government stand, only the department which are having more than 13 numbers of drivers, only then there can be a head driver. So most of the department which the petitioner now claiming where there are no head driver, they have less than, some are 18 drivers, 3, then 8, 2.
What is the
Five.
requirement, madam? You have said that
It should be 30.
30. When
Yes.
there are number of drivers in a department is 30?
30, there will be one person will be designated as head driver. So when the number is very less, Lordship, and most of the departments are infant. So the upgradation of the senior driver to head driver is not feasible, Lordship. That is the stand of the government department.
Yes.
Yes, that's all, Lordship. Yes.
Yes, what do you say? Your right flows from which order? There is no order as such.
Lordship, when the meeting was taken on, then on 13/8/2010, Lordship. But then when the meeting was being taken, the existence of the state office order which was placed by the state respondents was fully in knowledge of the government, Your Lordship, respondents.
No, that we have understood. So,
Yes.
there are two issues.
Lordship.
First, you have to overcome that this resolution can be acted upon. It can be deemed to be an order.
Lordship.
Let us assume that you are successful in convincing the court that the government is also bound by this resolution.
Lordship.
Then the next legal aspect would come, which Madam has highlighted, that
Lordship.
there is a particular requirement that a department or a directorate is required to have at least 30 numbers of drivers so as to designate one of the senior-most driver to be the head driver.
Lordship.
Now, most of the departments do not have 30, and few of the departments are infant departments, new departments, with very less numbers of drivers. And it is already on record that out of the 39 departments, only 12 are left out.
Lordship.
Can we give it as a matter of a mandamus that in all the departments or directorate, irrespective of the numbers of drivers, or the designation has to be done?
Lordship, regarding the strength of the drivers, Lordship.
Yes.
Among the 39 departments, just some of the departments who even reach even 20, they've already granted. I have enclosed in my additional affidavit. I'll produce before the Honorable Court, Lordship.
Hmm.
And then, firstly, Lordship, after the meeting was held on
Yes.
13/8/2010, my annexure to Your Lordship, page 20,
Yes.
the Deputy Secretary to the Government of Nagaland Transport Department,
Hmm.
Transport Department, have issued an office letter to all the department in the state, Your Lordship,
Hmm.
stating that a meeting is being convened, and then it was agreed in principle that one post of head driver shall be provided to all the directorates and DC offices, and also further requested to inform the transport department as to whether their office has been created the post of head driver or driver's supervisor or not. The department government itself is circulated the office letter to all the departments, page 20, Lordship.
But this, Madam, this minutes of meeting was headed by the Chief Secretary, isn't it?
Sure.
Now, this was in context of what? There was some memorandum by the association.
Lordship.
He had given an memorandum that was considered and these resolutions were taken.
Yes.
But this resolution needs to be transmitted in the form of an order.
Yes.
Yes,
That-
Lordship. Why? Because, as I've stated earlier, that's
No,
why
Mr. Council, we do not have any problem if the department,
Lordship.
in aberration of the requirement,
Yeah.
they thinks that, but it cannot go as a mandamus from the court. if it's sanctified by the code, we need to be strictly in accordance with law.
Lordship. Then Lordship,
While there may not be a bar for the department to consider, we
Lordship.
cannot say that you have to give a head driver. If the 30, that is not, even in that aspect, you may have some other reasons that it may not be feasible. It depends, you may not have the finance, you may not have the resources.
Lordship, one thing if I may, Lordship. In my affidavit, additional affidavit, Lordship, in paragraph 2.
No, we have noted it, that in certain departments where numbers are less than 30.
Yes.
That we have noted. For them, they can do it. There is no bar
Lordship.
to make a slight deviation from the rule. If this, but to go as a mandamus is difficult. Madam, what is that case where it has been laid down that unless it is in a form of an order, you cannot enforce it?
Lordship, right now,
You should be equipped with that matter, with that case law. There are case laws that internal office notes will not give any right, vest any right. But this is more than an internal office note. This is a resolution by a high-powered committee.
Lordship.
Headed by none other by then the chief secretary. And this meeting was conducted specifically on the representation of the petitioner. It's not that many agendas were there, one of the agendas is only to represent representation of the petitioner. What is your prayer?
My prayer, page 15, Lordship. First, that is, the honor in comply the meeting minutes dated 13/8/2010 and to treat on the principle of equality before law and equal treatment by law. And number 2, to upgrade the post of senior most driver to head driver under the departments mentioned in paragraph 6, that is the 12 departments, Lordship. But your Lordship, one thing is that 39, what?
Where is your representation?
Page 22, annexure 4, Lordship. Page 22 of my writ petition, annexure 4.
Have you answered this representation, madam?
uh,
15/3/2022.
Lordship, if we read, this is the representation, the highlight about the meeting held on 13/8/2010.
Correct.
Yes, that's all.
No, they are seeking making a claim based on 13/10/2010.
Yes.
Have you responded to this representation?
Lordship, since the petitioner nowhere in his pleading stated that we have not answered to his representation, so we have not made any comments in our affidavit, Lordship. But Lordship, just because some department they are giving designating some person as a head driver does not give any indefeasible right to the petitioner to claim for the post.
As a mandamus, perhaps we'll not be able to help you, but we'll make some observations
Lordship.
that there will be no bar for them to consider. Okay.
Lordship.
Okay. Yes.
May Lordship, if I may, Lordship,
Yes.
my additional affidavit, paragraph 2 may also be stated, Lordship.
Yes, that other
That
paragraph?
Paragraph 2 of my additional
2.
affidavit.
Okay. The All Nagaland Directorate and District Government Drivers Union, bracket so and so, AANN, and the All Nagaland Directorate and District Government Drivers Union, bracket, have joined together in this petition filed under Article 226 of the Constitution of India with the following prayer. Page 14. Para. As per the facts project, as per the facts projected, comma, the petitioners, both the petitioners constitute of the drivers in the aforesaid departments and directorates. Full stop. Directors and are espousing the cause for its members. Full stop. The edifice of the present claim is a resolution of a high-powered meeting dated 13/8/2010. Full stop. Since the entire case is dependent on the said resolution, comma, those are extracted herein below. Extract করে দিব, হ্যাঁ? Page, which page? Page that resolution, page 18. Okay.
17 is the 18 is the that copy, Lordship. 17.
Yes, 17. Okay. Para. It is the case of the petitioners that the aforesaid resolution has not been complied fully, and accordingly, the instant writ petition has been. No. Why is the second writ petition?
Second writ petition is for upgrading from head driver to vehicle inspector.
Okay.
That's different case.
Oh, then.
And then here, the main petition is from senior head driver, senior driver.
That is a separate cause of action.
Lordship.
So we'll hear it differently, what?
Lordship, in that particular petition, Lordship, a committee was constituted.
Now, why are these tagged along? Are these common? No.
Different pair pertaining, Lordship, similar in nature cases, Lordship.
That is also dependent on a resolution.
Lordship.
Same resolution.
Lordship, but then in the second case, Lordship, a committee was constituted, and then a meeting minutes was held. And then 16 departments have not been considered, even though the department is also forwarded to the government.
The facts are a little different.
Little different, Lordship.
Okay, well, we can dispose of both but separate orders will be there.
Lordship.
Okay. We'll dispose this off, then you can change the facts, then we can incorporate and okay. Equally. Has not been complied fully, and accordingly, the present writ petition has been filed. Para. 3. So learned counsel for the petitioners has informed that out of 39 departments and directorate, comma, till date, "27 departments and directorates have implemented the aforesaid resolution, whereby head drivers have been appointed." First of, however, 12 numbers of departments and directorates are yet to have a head driver. Full stop. He submits that the resolution should be complied in its entirety, as the same was taken on the representation of the petitioners, which finds mention in the resolution itself. Full stop. Para. Per contra, Ms. So-and-so, your learned AG, has submitted that has firstly submitted that the resolution dated that the minutes of meeting dated 13/8/2010 shall not vest any indefeasible right to the petitioners to make the present claim. Full stop. She has specifically contended that unless the minutes of meeting is given in the form of an order, comma, no rights would be vested upon any incumbent. Full stop. Para. The Learned State Council has otherwise submitted that the resolution, that the minutes and that the resolutions can be implemented in accordance with law, which requires that a head driver can be appointed only when the numbers of drivers in a particular department or directorate is 30, full stop. 30, and in fact, in those departments, directorates, which fulfill the aforesaid requirement, comma, head drivers have been designated, full stop. She has submitted that when the requirement is not fulfilled, comma, the aspect of such designation as head drivers would not arise. Full stop. She has also highlighted that few of the departments are very new departments where there is no requirement of such head drivers. Full stop. Para. Sri, so, Leonard, are you appearing separately, madam?
I'm appearing in 221.
Okay. Well, as a state counsel.
Standing counsel for respondent number 6 and 21.
Who's 6 and 21?
That is the Directorate of Social Welfare.
Okay, we'll respond. Sri Sensor, Leonard State, Leonard counsel for the petitioner by referring to the additional affidavit filed on 30/5/2025 has submitted that for departments directorates having less than 30 numbers of drivers have also designated head drivers. Full stop. He has specifically referred to the averments made in paragraph 2 of the said additional affidavit. He submits that when the state government has taken a decision to designate head drivers in departments directorates having less than 30 numbers of drivers, comma, such decision is required to be implemented in all the departments directorates. Full stop. Para. The rival submissions have been duly considered. Para. From the materials placed on record and from the arguments advanced, it appears that the entire basis of the present claim is the resolution taken in the meeting dated 13/8/2010, the relevant part of which has already been extracted above. Full stop. It is true that a resolution was taken to have a head driver in each of the directorate and DC office. Full stop. And full stop. It also transpires that out of 39 departments, 27 departments have already fulfilled the said resolution by designating one head driver in each of those. Full stop. The petitioners have claimed their case on the aforesaid resolution. Full stop. On the other hand, it is contended on behalf of the state that there was no order passed subsequent to the aforesaid resolution, in absence of which no vested right would be conferred upon the petitioners to make any claims. Full stop. Para. The aspect of an order following a decision has been explained by the Honorable Supreme Court in a number of decisions. Full stop. In a number of cases. Full stop. In this regard, one may gainfully refer to the case of Bachittar Singh versus so-and-so, wherein the following observations have been made. Full stop. Para. This court is of the considered view that in absence of an order, no claim can be made by the petitioners, as no indefeasible right has been vested upon the petitioners. Full stop. At the same time, this court cannot be oblivious of the fact that the resolution taken in the meeting dated 13/8/2010 was taken up for consideration, and it is a matter of fact that in 27 numbers of departments, there has been appointment of head driver, full stop. The London State Council has contended that out of the most of the that there is a requirement of having a minimum of 30 numbers of drivers so as to designate one of the drivers as head drivers, comma. Most of the departments have drivers who in most of the departments, the number of drivers is less than the required 30, and few of the departments are very new, full stop. This court has also taken note of the argument advanced as well as pleaded in the additional affidavit that even in departments having less than 30 drivers, comma, head drivers have been appointed, full stop. Para? Not para. This fact has not been disputed by the learned by the Learned State Council, full stop. Para? While disputed, full stop. However, the Learned State Council has hastened to add that any aberration in law would not give any right, as the rights under Article 14 is positive in nature, full stop. Para? Be that as it may, comma, while this court is of the opinion that the present claim cannot be made as a matter of right, comma, since a resolution was adopted, and it also appears that in few of the departments, the strict requirement of having 30 drivers has been relaxed, comma, the state may take appropriate action for reconsidering as to whether there would be requirement of having a head driver in the remaining 12 numbers of Directorate / DC office, full stop. If, in the opinion of the state, comma, such redesignation, such an action is required, comma, the same may be taken in accordance with law, full stop. The aforesaid exercise may be completed within a period of 4 months from today.
Lordship, I'd like to identify Lordship. Instead of 27, Lordship, it's 39 departments, Lordship, who have granted head driver.
39 we have said.
Lordship, not 27.
No, 27. You said 12 has not been done.
13 out of 39 departments have been done and 12 have not been done. 39 have been granted already.
Okay. 13 already granted.
Yes.
Okay, 12. Oh, okay. 12 has not been. Okay. Take 39 of DC already. 12 has not been given. Okay, 27 now. And in the other case?
In the other case, since the similar in nature, I'll just take you to Annexure 9, page 51.
Page 51. Yes.
Lordship, kindly page 50 again, Annexure 8, Lordship.
Yes.
Page 50.
Yes.
After the petitioner submitted the representation, Lordship, here a notification was issued where a committee was constituted to examine the petitioner's demand. It was issued by the Undersecretary to the Government of Nagaland Transport Department.
Yes.
And then on the next page, that is page 51, Annexure 9, the report, I'll take you to relevant part, page 52.
51 is the minute submitting.
Lordship. May I read, Lordship, this paragraph?
Yes.
After examination and deliberation, the committee.
Paragraph 4.
Paragraph 4, Lordship.
Yes.
Page 32.
Yes, 52. Yes.
After examination and deliberation, the committee concluded that the demand of the All Nagaland Directorate and District Government Drivers Union for creation of 62 posts of vehicle inspector and all directorates and deputy commissioners' offices in the district was not functionally justified. The committee recommended that it should be left to the wisdom and discretion of the departments as to whether the post of inspector is required in their respective departments, and if so required, move proposals to the state justifying for the same, Your Lordship. This was the committee report, Your Lordship.
To that discretion was.
Yes, it
given.
was given to the department. Then
Yes.
accordingly, as many as department have submitted proposal to the before the
How many departments?
I've enclosed only 8 departments, Your Lordship, here. 8 departments they have considered, Your Lordship.
8 departments considered.
Yes, Lordship.
Then?
And then another 16 departments, even though they have forwarded, they have not been considered till date.
Oh. Okay. And what is your case? What do you want?
With the direction to
Have one post of vehicle in the
inspector, yes,
vehicle inspector.
yes, within the 16 departments. Why? Because the committee is clearly keeping the report that it.
Madam, you appear for?
I'm
You're
for-
also appearing, Madam AG? AG, you're appearing, okay. For the state respondent, and you are for?
Lordship, I'm for respondent number 6 and 21. That is the Department of Social Welfare, Lordship.
You have filed affidavit.
Lordship, I am fine, Lordship.
And Madam, you have filed affidavit, state has filed. Affidavit. Okay. Okay, so almost same directions we'll have.
Lordship,
In 8,
they have granted.
they have appointed vehicle inspector.
Lordship.
16 it's remaining.
Yes. And then it was to be done between the department only. Why? Because it was.
But is there any requirement like you had argued in the other case that there has to be a minimum of 30 drivers?
So I stated that, there is no service rule which governs the driver.
Okay. So in absence of any rule,
They are demanding for the post of vehicle inspector.
yes.
So the post of vehicle inspector is a promotional post.
Mm.
Yes. And the committee, they have given the recommendation that it is left to the wisdom and discretion of the department.
No, we can say that if it is a promotional post,
Yes,
as and when the promotional exercise is done,
yes.
the members, suitable members, eligible members, they can
They
participate.
can participate. But now they are claiming for the accreditation. Earlier they claimed for the post creation where it is not feasible. Now they are coming in the form of the repetition, claiming for upgradation of the post. So for the upgradation of head driver to vehicle inspector, Your Lordship, it's up to the discretion of the department, Lordship. And when there is a few drivers, Lordship, the upgradation to vehicle inspector post is not feasible.
It's not permitted by the rules.
Yes.
But have you created 62 numbers
No,
of?
we have. And most of the department, they sent the proposal to the government, but most were declined. And some were waiting for the MRC.
What is MRC?
MRC is the
Manpower.
Manpower Rationalization Committee, Lordship.
This will be a different order, but we can leave it, but it cannot be an upgradation if the rules.
Yes,
cannot-
Lordship, regarding that submission, Your Lordship. Discretion was given to the department, Your Lordship. The department is forwarded before the government. Now the government itself, they are denying it. And then the department itself clearly stated that why they need a vehicle inspector. Why? Because the workload is very high. And then moreover, the maintenance of vehicles.
No, but if the rules prescribe that the
That's why,
post,
Lordship,
that the
yes.
post of vehicle inspector can be filled up only by promotion,
Yeah.
whether they create or not. Now, first creation is their
Lordship.
discretion prerogative. It will have many other ramifications, including finance.
Lordship, on that, Lordship, I should. Regarding draft rules, it's been submitted before the government, Lordship. Since draft rules are not there, that's why a committee was constituted, Lordship. Report is already there. And then secondly, regarding the financial implication, the affidavit which the state respondents have enclosed, they've clearly stated that no final implication, it's just an accreditation to the post of vehicle inspector, Lordship.
The vehicle inspector post and the post of head drivers are those in the same cadre? Cannot be.
Lordship.
There will be a higher remuneration. Everything will be once there is higher remuneration, everything will be different. financial impact will be there.
Lordship.
Okay, we'll pass a similar kind of an order. We'll ask them to consider for promotion as and when the members will. It will order available.
As far as with regard to the Department of Social Welfare is concerned.
Yes.
We have sent a proposal, however, the PNR has revert back to the department to send a proposal again, Lordship. So the discretion does not lie solely to the department concerned alone, Lordship. So we have given the, in response to the letter sent by the PNER department.
Okay.
The proposal has been sent
Dictation
out.
did evening, did you dictation to it? Huh? Is it? Okay.
Lordship, if I may be allowed to place two rulings, Lordship.
Yes, please.
The first case is 1974 for ACC.
Rapper.
Lordship.
Rapper. These are not promissory estoppel, Padampat, Motilal Padampat. And rapper for what?
Your Lordship,
Which paragraph?
paragraph 85, page 30, Your Lordship. I'll just state the relevant pages only. Para 85, page 38.
Yes. Yes, please.
It's regarding Article 14 and 16, Your Lordship.
Yes.
Why? Because
yes,
some of the departments have been considered, whereas the other departments have been considered. On that line, I'm posting this. And then in the next judgment,
yes,
1979 to ACC 409. Paragraph 24, page.
Motilal Padampat.
Lordship.
On the aspect of promissory estoppel.
Lordship. Page 24, paragraph 24, page 442, Lordship.
Paragraph
24, page 442.
Yes, please.
So may I read, or Lordship?
Which part?
Paragraph 24.
Yes.
I'll just read from the third paragraph, Lordship.
Yes.
For safe time. The law may therefore now be taken to be settled as a result of this decision.
Promise made by the government, promissory estoppel.
Lordship.
Okay, we'll dictate it right now, because if there is any factual thing, clarification you can give, otherwise it will be a problematic thing, okay? Here again, the same union. Same union.
Lordship.
Okay. You're not required to give all the office, all the annexures in the cost title, okay? Cost title is a very precise way of communicating to the court what is your problem.
Lordship.
You're not required, see page 2, page 3, page 4, page 5. You're not, the cost title needs to be very precise, maximum 3 pages, it should be 2 pages. Why have you come, which article, and that's all. And the names of the parties. That is, of course, you cannot avoid, you have to give all the parties. Okay. The All Nagaland Directorate and District Government Drivers Union, bracket A and D, from page 7, and the All Nagaland Directorate and so-and-so, bracket so-and-so, have joined together in this petition filed under Article 226 of the Constitution of India with the following prayer. You kindly extract the prayer from page 36, or is it 30? No, 35. 35, okay? Page 35, prayer. Okay, extracted. Para. As per the facts projected, comma, there had been a long-standing demands of creation of post of vehicle inspectors in the in the various departments. Full stop. In this regard, on 13/10/2014, a committee was constituted to look into the said demand, and the aforesaid committee took a resolution in its meeting dated 30/1/2015. The relevant part of which is extracted here in below, page 52, resolution number 4. Full stop. As per the aforesaid resolution, comma, the committee had recommended that the aspect of creation of 62 numbers of posts of vehicle inspectors should be left to the discretion of the departments as to whether such post is required, and if so, the state governments may be moved. Full stop. It is the case of the petitioners that 8 numbers of departments have in fact considered the aforesaid resolution positively, and vehicle inspectors have been appointed. Full stop. However, till date, 16 numbers of departments have not considered, and accordingly, the present petition has been filed. Full stop. Para. I have heard Sri so-and-so, learned counsel for the petitioner, Ms. so-and-so, learned AAG for the state respondents, and Ms. so-and-so, learned standing counsel for the respondent number 6 and 21, dash Department of Social Welfare. Full stop. The state respondents, as well as the concerned Department of Social Welfare, have filed affidavits in opposition. Full stop. Para. Sri so-and-so, learned counsel for the petitioners has submitted that the action of the government in constituting the committee wide notification dated 13/10/2014 was for redressing the demands and grievances of the petitioners, which the committee had accordingly done in its meeting dated 30/1/2015. Full stop. He submits that the observations made in paragraph 4 cannot be read in isolation and has to be read with the observations made in the earlier part of the meeting, as well as the contents of the representations of the petitioners. Full stop. He has submitted that while the discretion was left to the concerned departments, comma, the same should have been taken up positively by all the departments, and only 8 numbers of departments have appointed vehicle inspectors, and 16 departments are yet to make such consideration. Full stop. He submits that promotions, upgradation in service is a cherished right of every employee, and that right is required to be, and no employee can be deprived of such rights. Full stop. Para. Per contra, Ms. so-and-so, the learned AAG, has submitted that the post of vehicle inspector, has submitted that the aspect of creating 62 numbers of posts of vehicle inspectors in the directorates and deputy commissioner's office in the districts was not feasible. and the post of vehicle inspector is otherwise a post which can be filled up only by promotion, full stop. She has highlighted that the petitioners have prayed for upgradation of the post of head drivers to vehicle inspectors, which is not provided in the rules. Full stop. She has categorically submitted that 62 that the aspect of creating 62 numbers of additional posts of vehicle inspector could not be done, as it was not feasible on the part of the state. Full stop. She accordingly submits that the petition is not does not warrant any. She has further submitted that no right of any nature has been vested on the petitioners by the observations made in the minutes of meeting dated 30/10/2015, as there is no corresponding order flowing from the said discussion. Full stop. In any case, she submits that the resolution was not even in the form of a direction, but leaving the matter to the respective directorates oblique office of the deputy commissioner to exercise its discretion. Full stop. She has also submitted that for those departments which have forwarded the proposals, those have been considered in accordance with law. Eight departments you have said? Law. Full stop. Para. Miss so-and-so, Standing Council, Social Welfare Department has, however, submitted that the said department had forwarded certain proposals which were considered, and what is the
Which was sought by the Personal and Administrative Reforms Department.
okay, then it was sandbag.
Yes, Lord.
Was forwarded by the department, which, however, after consideration, was declined by the Personnel and Administrative Department.
Lordship, proposal was sent. However, the Department of Personal and Administration Reforms Department has sought for
Other
further
proposal.
detailed
Okay.
proposal, Lordship.
No, don't say declined. Please read the line. Please have you seated. Not declined. After certain consideration, was reverted back to the department for submitting a fresh proposal. Full stop. Para. Sri so-and-so in his rejoinder has submitted that when 8 numbers of departments have considered and appointed and made appointments to the post of vehicle inspectors, it will not lie on the government to deny a similar action for the remaining 16 numbers of departments. Full stop. By relying upon the case of E.P. Royappa versus so-and-so reported in 1974, 4 SCC, page 3, the Learned Council has submitted that the action of the department would be in violation of Article 14 of the Constitution of India. Full stop. He has made specific reference to the observations made in paragraph 85, which are extracted herein below. Page 80, para 85 or Royappa. He has also relied upon the case of Motilal Padampat versus so-and-so, reported in 1979, 2 SCC 409, on the aspect of promissory estoppel. Full stop. He has submitted that the resolution dated 30/1/2015 would amount to a promise which the government cannot resile. RESILE. Full stop. The rival submissions have been duly considered, and the materials placed before this court have been duly considered, have been carefully examined. The demand of the petitioners, which would reflect from the minutes of meeting dated 30/1/2015 of the committee constituted by notification dated 13/10/2014 would show that it was for creation of 62 numbers of posts of vehicle inspectors in all directorates and the office of the deputy commissioners. Full stop. As the said committee had, however, did not issue any direction for such creation and had rather left the matter to the discretion of the respective departments. Full stop. The observations of the committee, which have been extracted above, would clearly show that the matter was left to the discretion and wisdom of the respective departments. Full stop. Para. This court has taken consideration of the fact that the post in question of vehicle inspector is a promotional post, and therefore there cannot be any demand for upgradation. Full stop. The learned AG has made a categorical statement that the aspect of creating 62 numbers of post of vehicle inspector was not found feasible and therefore could not be created. Full stop. So far as filling up of any vacant post of vehicle inspectors is concerned, the same can be done only by following the rules holding the field, which lays down that it has to be done by promotion. Full stop. Para. This court has also considered that 8 numbers of departments has recommended for creating. They have created posts.
Upgradation.
8 numbers of departments have considered and proposed for upgradation of post from the post from head driver. What is it? Head driver to vehicle inspector. Full stop. Full stop. While 16 number of departments are yet to consider. Full stop. Para. This court is of the opinion that firstly, the resolution of the meeting held on 30/1/2015 is not in the form of any direction. Full stop. In any case, there was no order following the said resolution, and it is a settled principle of law that in absence of any order, no right of any nature would vest on any incumbent. Full stop. In this regard, one may gainfully refer to the decision of the Honorable Supreme Court in the case of Bachittar Singh. I'll give you the citation, wherein the following observations have been made. Full stop. Para. Be that as it may, even if the aforesaid aspect is overlooked, the observations made in paragraph 4 are not in form of any direction. Full stop. Para. So far as the action of 8 departments are concerned, recommending upgradation, this court is of the opinion that such recommendation would be can be termed to be taken in exercise of discretion, which, however, do not conform strictly to the requirements of law, whereby the post of vehicle inspector is to be filled up only by promotion. Full stop. In view of the above, this court is of the opinion that no mandamus can be issued directing upgradation of such post. Full stop. The vacant post of vehicle assistant can be filled up only through promotion. Full stop. However, if it would be the discretion of the respective departments and the government to allow upgradation, which however has to be done in a transparent and fair manner, giving equal opportunity to all the deserving persons. Full stop. Pero, with the following observations, the writ petition stands disposed of. Our court master will give this you back, okay?
Lord,
We don't need to retain here in the, well, now it will be retained, tomorrow it will be given back. That's all. This will be here. This will be in the other one.